Sonia, are you there?
Yeah, hi, how are you?
Good, how are you? This is Paul.
Pretty good. Thanks for joining me this morning.
Sure. Is it just you and I so far?
Think so. Oh, and
Oh,
Pam.
somebody else just joined.
Yeah.
Do you want me to turn off video?
You don't have to. I do ask that you mute yourself until the end.
You got it.
All right, so I'm going to go ahead and get started. Thank you so much for joining me this morning for the Fair Housing and CHIP free online webinar. My name is Sonia Pagnano, and I'm the Associate Planner for Medina County Planning and Fair Housing Office. And this presentation is geared towards Wadsworth City and Medina County staff, especially building, planning, and zoning departments. So in this presentation, we are going to go pretty deep with zoning and fair housing, and we'll be touching on building and fair housing as well. So today's agenda, first we'll cover the Fair Housing Act, then we'll go over our fair housing process, then we'll go into fair housing and zoning, and then fair housing and building codes, and then CHIP funding. And then there's a question and answer portion at the end. If you do want to ask questions as I'm presenting, please feel free to use the chat option. And I'll be keeping an eye on that to see your questions. So the Fair Housing Act. The Fair Housing Act protects people from discrimination when they are renting or buying a home, getting a mortgage, seeking housing assistance, or engaging in other housing-related activities. The Fair Housing Act covers most housing. In very limited circumstances, the Act exempts owner-occupied buildings with no more than 4 units, single-family houses sold or rented by the owner without the use of an agent, and housing operated by religious organizations and private clubs that limit occupancy to members. Here's a little bit about the Fair Housing Amendments Act that will be referenced later in this presentation. It was signed into law on September 13th, 1988, and became effective on March 12th, 1989. The Act amends Title VIII of the Civil Rights Act of 1968, which prohibits discrimination on the basis of race, color, religion, sex, or national origin in housing sales, rentals, or financing. So our fair housing process is pretty simple and straightforward. If you do have a fair housing complaint, you would call our office, 330-722-9219, or you can use our fair housing email address. It's mcfairhousing@medinaco.org. We do have a fair housing coordinator. Her name is Cheryl Heinley, and she handles any of the complaints that enter our office. She evaluates these complaints, and she'll offer intake paperwork, which can be completed in person or emailed or mailed to be completed at home. The intake paperwork does have to be completed in order for an investigation to occur. We do sometimes provide consultation on issues when people aren't comfortable completing intake paperwork. Often they'll just call again and talk to her. But complaints can also be filed or forwarded directly to the Department of Housing and Urban Development, also known as HUD, or the Ohio Civil Rights Commission, OCRC, for further investigation and determination. So a lot of these cases that I'll be going over in regards to fair housing and zoning, they come from www.disabilityrightspa.org. I do think that they can apply to anywhere in the United States. Just keep in mind, I'm not an attorney, and if you do have a legal question, you will want to consult someone for legal advice. And these are really just examples of cases that have occurred and were found to be discriminatory. So the following summarized zoning cases demonstrate that intentional discrimination can take many forms. For example, requiring a zoning application for a special exemption Exception to provide a residence for persons who are HIV positive was deemed to be the result of intentional discrimination where there was significant community opposition. The residents met the town's zoning criteria for a family residence, and the zoning officials departed from normal procedures in considering the issue. Requirement that a group home apply for a variance and the local government's issuance of summons for noise and parking violations were the result of discriminatory intent. The intent was revealed by community opposition and the fact that no similar citations had previously been issued. Reversal of initial decision that a group home for recovering substance abusers was a permitted use under the zoning ordinance following expression of neighborhood and city council opposition evidenced discriminatory hatred in violation of the act. A town's amendment of its zoning ordinance to bar an assisted living facility in a zone following expressions of community hostility evidenced discriminatory intent in violation of the FHAA. A one-year moratorium on new adult care facilities for persons with disabilities was held to be a, quote, classic case of discriminatory treatment because the ordinance was passed with the intent to discriminate against, end quote, persons with mental impairments. A court found evidence of discriminatory intent in enacting a zoning ordinance requiring that group homes be separated by at least 1,000 feet, where the evidence established that the officials imposed the requirement in response to community fears and concerns about property values. A municipality's refusal to permit a nursing home to operate in a mixed residential zone violated the reasonable accommodation mandate. A community's failure to grant a reasonable accommodation of its minimum side yard requirement for a single room occupancy facility for persons with mental illness and recovering substance abusers violated the reasonable accommodation provision. Denial of special use permit for halfway house for recovering alcoholics may have been a result of intentional discrimination. Statements by decision makers reflected that the decision was based on the identity of the clients and that the legitimate reasons advanced by the city, for example, safety concerns, could have been pretextual since the city allowed the development of a child care project on the same property on which the halfway house was to be developed. Please keep in mind, anytime communities email our department regarding issues that could be discriminatory, for example, focusing zoning on regulating Amish communities, that any future actions could result in that community discriminating through zoning, regardless of what their initial intentions were. You might be asking a simple, innocent question, not realizing that you are discriminating against a group of people. So be cautious about what you write and what is on record, and keep in mind attorney-client privilege for questions where you are unsure and could be discriminating without intentionally doing so. This is especially important for text amendments that are sent to our office. As you can see in that previous example, there were statements by decision makers that reflected that the decision was based on the identity of the clients and that the legitimate reasons by the city, so safety concerns, were really just pretextual because they also had a child care project that they were looking at as well for that. So just always keep that in mind. You might have the best of intentions, you might think you're doing the right thing, but that has come up recently several times, so we want to make sure communities are aware of that. So again, with the Amish example, there's also issues with public versus private schools. And Amish schools that maybe function as churches, you might want to regulate churches and education together, but you have to keep in mind the context of why you're doing so. Like, is that only going to affect Amish populations? And maybe write your zoning more general so it covers any kind of situation. So for example, in 1932, the Supreme Court of Oregon in Roman Catholic Archbishop v. Baker held that a zoning ordinance may not discriminate in favor of public schools and against private schools in the matter of their location in a residential zone. And always keep in mind when you're looking at churches or other religious assemblies or institutions, the RLUIPA prohibits zoning and land use laws that treat churches or other religious assemblies or institutions on less than equal terms with non-religious assemblies or institutions. Discriminate against any assemblies or institutions on the basis of religion or religious denomination. Totally exclude religious assemblies from a jurisdiction, or unreasonably limit religious assemblies, institutions, or structures within a jurisdiction. So a municipality's failure to issue a variance to its zoning laws to allow the operation of a single-room occupancy facility for persons with mental illness and recovering substance abusers in a commercial industrial district was deemed likely to violate the reasonable accommodation provision for that community. Refusal to waive zoning laws that restrictively define quote-unquote family and or limit the number of unrelated persons who may live together to bar operation of group facilities have been held to violate the FHAA's reasonable accommodation provision. So again, please note, zoning is not for regulating individuals or specific groups of people. It is to regulate location, size, and use of buildings and lands, not to regulate types of individuals. Anytime you talk about zoning, do not relate it to specific groups of people or things that could be individualized for maybe a person. So next we'll move into the Fair Housing and Building Code section. These are additional examples that really relate more to building departments, but you might see some similarity as well between that and the zoning. Excessive police activity and regulatory actions designed to force residents out of home for recovering substance abusers stated claim for intentional discrimination under FHAA given statements of officials that they objected to the residences. The denial of a permit to allow renovations for a group home for people who are mentally ill and substance abusers was held to be the result of intentional discrimination in violation of the act where the decision was based on objections to the residents' handicaps. There was a statute that placed special burdens on boarding homes, for example, requiring new certificates of inspection each time a new resident moved in, or posting bond to cover relocation costs in case a facility was forced to close, and requiring homes to obtain zoning permission even when they are in properly zoned areas, was freighted with discriminatory intent and violated the FHAA. Imposing rigorous safety requirements on homes for individuals with developmental disabilities and not tailoring those requirements to specific types of disabilities violated the act. Refusal to waive requirements concerning sewage disposal that would allow operation of assisted living facility was likely a violation of the FHAA's reasonable accommodation requirement given the facility's workable proposal to address the sewage issue and the town's accommodation of such issues for other developments. So a big takeaway from that last section is do not treat other people differently than you're treating the general public. That's an immediate red flag and will lead to a potential lawsuit. So next I'll be moving into the Community Housing Impact and Preservation Program funding. You guys are probably already pretty familiar with this kind of funding, but generally the purpose is to rehabilitate a one-family housing unit, which is owned and occupied by low and moderate income households. Some eligible items in this program include installation and or repairs to foundations, roofs, gutters, electrical upgrades, plumbing, furnaces, hot water heaters, insulation, windows, doors, accessibility improvements, and lead-based paint abatement. This program provides deferred loans in an amount up to but not exceeding $35,000 to low-income homeowners for the purpose of eliminating existing substandard housing conditions. If the applicant is eligible, they do have to agree to a few conditions. The first is to occupy the home for at least 5 years after the rehabilitation. The second is to reimburse the program 15% of the total grant when the home is sold or vacated after 5 years. So it'd be 15% of $35,000. Reimburse the program on a sliding scale up to the total amount of the grant if the home is sold or vacated before the 5-year anniversary. They tend to be pretty reasonable with that. And then the fourth is to be willing and able to allow the administrating agency to retain a mortgage on the property. And finally, be willing and able to reimburse the program as agreed if the home is sold or transferred as part of the current owner's estate. So the program income guidelines, I know in the last presentation, someone was shocked at how low income you have to be to qualify for this program. And honestly, we are worried between the new census and the administration that might be lowered again. So a one-person household making $30,150 a year or less would qualify, as would a four-person household making $43,050 or less. So obviously, it's looking at a very small portion of Medina County's population. I think a lot of people are uncomfortable when they only make that much money to take out a loan, because this is a loan program. But if you do qualify or you know someone that might, please encourage them to apply. This is a really great way to invest in your home and increase its value. So household income is determined by the total gross income for the previous year reported on federal tax forms by all household members 18 years of age or older living in the home. Forms that you could turn in to prove your income are the IRS 1040, W-2s, SSA 1099, and others. Proof of current income must also be provided to ensure eligibility at the time of application and to determine an income projection for the next 12 months. I always encourage people that are maybe on the line of qualifying, if they can find a way to just get their income down a little bit for that next year, to try to do so that you qualify. So if applicants are interested in participating, they need to complete an application and call to schedule an appointment to submit the application. When they turn in their completed application and all the necessary documents, they will be verified to determine their eligibility for the program. It is a first come, first serve program, and you need to have a completed application and all of your necessary documents when you apply. Otherwise, your application will be denied. If you want more information, you can call 330-410-6581. They're located in our building. That's the professional building in downtown Medina on the 3rd floor, 120 West Washington Street. And people that are eligible are any residents of Medina County. City of Wadsworth does have their own, and so does the City of Medina. But City of Wadsworth is tied in to the counties. So if you are in Wadsworth, you go to this office at 120 West Washington. If you're in the county, you go to that office. But if you're in the City of Medina, you should call them first at the city so that you know where to go. Do you have any questions? Awesome, Montville. Thank you so much for joining me today. I really appreciate your time. And I hope we can do this again soon. Thank you. Thank you for joining me. I appreciate it. Oh, and this meeting will be available as a recorded meeting. So if you're interested in watching it again or whatever, just let us know.